Welcome to the University of New Mexico Law and Mental Health Didactic Series. This is a series hosted by the University of New Mexico, Department of Psychiatry and Behavioral Sciences, and the New Mexico Behavioral Health Services Division. We're very happy to have all of you join us today. I'm Anthony Perillo. I'm the Forensic Psychology Training Director here at the University of New Mexico in the Department of Psychiatry and Behavioral Sciences. For the talk today, if you have any questions that you'd like for our presenters, ask those in the Q&A box that should be at the bottom of your Zoom screen. Anytime that you feel comfortable, we will hold those off until the end, but you can ask questions in that box anytime during the talk. For those of you that are pursuing continuing education credits but on a tight schedule, you do have to stay for the full hour, but you don't have to stay longer than that. I'm about to give you the information on the CE credit process, which you can do before, even if the talk itself the questions go beyond the full hour. Those pursuing continuing medical education credits, there will be a sign-in in the chat shortly. You'll be able to do that in order to pursue your continuing education credits. For those pursuing APA continuing education credits, a link will be posted in the chat box around the last 5 minutes or so of the talk. Make sure you open that before you leave this Zoom session and that you save the certificate from the survey that you complete. We don't get access to those, and once this is closed, we won't be able to send the link out later on. A recording and PowerPoint slides for this should be available within about a week. And as a heads up for next week, we will have Dr. Ofer Zur, who will be discussing therapeutic ethics on display in movies. But that's for another day. Here today, I'd like to present to you, it's the time we've been waiting for. I'd like to introduce you to today's speakers who will be discussing liability and risk management issues in forensic practice. We have with us today Dr. Jeff Younggren and Dr. Jana Martin. Dr. Jeff Younggren is a fellow of the American Psychological Association and is a clinical and forensic psychologist. He was a clinical professor at the University of California, Los Angeles School of Medicine, and is currently a clinical professor in the Department of Psychiatry and Behavioral Sciences here at the University of New Mexico. He's been a risk management consultant for the trust since the early 90s, so quite a while depending on your frame of reference there. Dr. Jana Martin became the trust CEO in 2010 after years of independent practice. As CEO, she's worked to provide more support services for policyholders, such as expanding clinical and risk management consulting and educational resources, and products for every level of psychologist careers. Dr. Martin was co-chair of the task force on the Development of Telepsychology Guidelines for Psychologists, and was co-editor on A Telepsychology Casebook, using technology ethically and effectively in your professional practice. Jeff, Jana, on behalf of the University of New Mexico, thank you so much for joining us. We're very excited to have you share your expertise with us and give us a lot to think about. I will now throw the floor over to you.
Well, thank you very much. Many of you have been regular attendees of this series that Anthony shepherds, and we've seen this program at New Mexico grow from 17 people to 700 during our presentations. Today we have 400 right now. People like to join late, so that seems to be what people do. It's absolutely fine to do that. This has been a real excellent addition to the program at New Mexico, but also services to forensic psychologists all over the country and the world. Actually, we have people attend from Asia and Europe as well. So it's a good and valuable resource for people. What we are doing today, and it's a pleasure to work with Jana. I usually work for Jana, which is a different thing, and to kind of help people understand risk and risk in the service of forensic issues, which is a very different kind of risk from the kind of risk that occurs clinically. Although the fundamentals are the same, the risk changes with forensic involvement, and many of you naturally know this when we say the magic words child custody evaluation, right? It's an adversarial situation, and so the risk is substantially different then. So what we want to do is to run through the fundamentals of malpractice so that you understand those. These are largely out of an article that Jana and Eric Harris and I wrote, it's cited at the end for those of you that want it, or you can email us and we'll send you that section on risk and malpractice and risk management in general. And then we're going to talk about risk in a broader base, which has to do with risk that has to do with licensing board actions or administrative functions, which people tend to minimize. And I think that's a significant error on their part. And then we want to make sure that we take the time to answer your questions about malpractice and risk. Jana, do you want to add anything to that?
I just want to say what a pleasure it is to be here with you, but also for the University of New Mexico. I'm delighted to be here and I'm looking forward to what we're both going to say.
Okay. All right. So we're going to go through the definition of malpractice. We're going to talk about the famous phrase, the 4 Ds of malpractice, what that means. We're going to talk about risk management considerations and related to administrative proceedings as well. And administrative proceedings are not necessarily civil or criminal proceedings, but are ethics committees, staff hearings, staff reviews, and those kinds of things. Reviews by insurance companies, assessing conduct. And then we're going to talk about the high-risk areas of clinical practice or forensic practice. Now, you know, we don't have a analyzed research project that talks about what are numerically the most significant areas. What do we have? Well, we have the results of some 70, 80,000 consults that we've done over the 30 years that Eric Harris started the consultation program. And so we know where the risks are. And someday in the future, we really need to publish an article talking about that in a more empirical way. But we know where the risk is, and we want you to know where the risk is. But first, let's talk about the concept of malpractice. And I think, is this yours or mine, Jana? I think.
Well, this one on the areas of professional risk is yours. I have the next
Good.
one.
I can't keep things organized. It's just a curse of getting older. It's all right. So what are the things we're going to talk about? We're going to talk about malpractice as a civil proceeding and define that for you so you understand it. We're going to talk about licensing board, and that is a different kind of proceeding. It's defined in the administrative code of your state. Licensing boards operate by it, and they have significant impact in terms of those proceedings as well, obviously, because they're evaluating your right to practice the profession or the need for the profession to monitor your practice. So they're regulatory. And then there's the administrative that I alluded to earlier, which is hospital peer review boards, ethics committee actions, sanctions that can come to you in a variety of different ways that have nothing to do with civil law or administrative law. And then there are criminal issues. And we're not going to spend a lot of time on criminal issues because you can't buy insurance for criminal issues. It's a crime. But what's important to understand as you look across these areas is that the level of proof required to find to register a finding against you is different for each one of those. And everybody kind of skims through that in a way saying like, well, they're going to prove that I did something wrong or not. That's true, but that's wrapped around the definition of what the level of proof is. Preponderance of the evidence, clear and convincing evidence, beyond a reasonable doubt. Those are different. And each one of those categories that we have up here is different. Probably one of the best examples that people have of the difference in the levels of proof that are required is that O.J. Simpson trial. O.J. Simpson was innocent criminally because the proof was not beyond a reasonable doubt. But civilly, he was guilty because the preponderance of the evidence sustained the action against him. So you need you need to understand that. And also, most importantly, this is not the world of psychology. This is the world of law. And so having assistance with individuals who understand the law, and specifically an attorney who represents your interest in these, is extremely important. But we'll talk about that later on. All right.
All
Jeff.
right. So it's always good to start out with definitions. So let's look at what malpractice really is. It is a special type of tort or civil wrong that's alleged against a professional. As forensic psychologists, those of you in the audience, you know that tort law holds a person responsible for any wrongful or negligent acts towards someone for whom they actually owe a duty of care. There's a responsibility for financial impact or harm which results from these acts. So, as summarized in the definition on the slide by Garner, malpractice is defined as any professional misconduct, unreasonable lack of skill or fidelity in professional or fiduciary duties, evil practice, or illegal or immoral conduct.
So let's talk about what are the 4 Ds of malpractice. That this is so basically what has to occur, as the slide says, for you to be found guilty of an act of professional malpractice. And the common terms are the 4 Ds of malpractice. But the first one may be the one that creates the most confusion, which I'll spend a little time on, which is the concept of duty, which is the D of duty. Now, duty is something that occurs when you establish a professional relationship with another individual. So it actually is the creation of kind of a legal mandate that you have to care for that individual, that you have a responsibility for the relationship between you and that individual. But the definition of duty actually changes depending upon the nature of the relationship you have with that individual. And people kind of in our profession want to say that duty is an all or nothing, when in fact, duty is a dynamic, it changes. And let me give you an example of how duty changes. Somebody calls you on the phone and you're a neuropsychologist. No, it's not, you're a forensic psychologist, because most of you are forensic psychologists. And they say they want you to do a neuropsychological evaluation, but you don't know how to do neuropsychological evaluations. What is your duty there? Well, you have some duty, but you don't have a lot of duty. You have the duty to lead this person to a resource that can meet their needs. And so the discharge of the duty is simply done by saying to that individual, I need to refer you to someone because I don't do this. And you've discharged your duty that way, or refer them back to their insurance carrier to get someone who can do neuropsychological evaluations. That duty is vastly different from the duty you have to a person that you've had in a clinical relationship for 5 years, that you've seen them twice a week for 5 years. And the duty of care is much stronger. And the responsibility is much higher. The duty that you have when an attorney retains you to do an evaluation is exactly the same kind of thing, is that you have a responsibility to act in that individual's best interest in meeting their needs. And if you can't, then you have a duty to transfer that to another individual. So in many ways, duty is elastic. Let me give you a place where we get into a lot of problems with duty, just as an example for you to understand how it is elastic. Because duty changes based upon the conduct of the client as well, right? And many will go like, Jeff, what do you mean? It's dependent upon the client. Well, let's talk about, all of you are trained clinically, so let's use a clinical example here initially, that you're in therapy with a patient and that patient then begins to stalk you or violate your privacy or create difficulties for you on the internet, start posting destructive things on the internet. And then you go like, well, what do I do here? I have this duty of care. Well, the client's conduct reduces the duty and responsibility. And there are many, many cases where termination is appropriate, and the duty of care has changed based upon the client's conduct. So you have to understand that the duty is elastic. Maybe one of the best cases to look up public record is a case called Ensworth versus Mulvane out of California, where a patient started stalking the psychologist. The psychologist became very concerned about it. The patient started sending threatening letters, threatening the psychologist's well-being, her family's well-being, and she eventually went and proceeded to obtain a restraining order against the client, and that resulted in a lawsuit alleging confidentiality, a breach of duty, et cetera, so forth. And the California courts were very clear in saying that the duty changed based upon the client's behavior. So lack of payment, inconsistent behavior with the informed consent, all those kinds of things change the duty. So, but the first thing you have to have is duty. If there isn't a duty, there is no civil action against you. The second one is a deviation from the expected standard of professional care. What are the rules for forensic psychologists? What are you supposed to do? What are you not supposed to do? Are you doing evaluations? Are you testifying as a subject matter witness? What are your obligations to the science of psychology? And how does your accuracy have to be wrapped around empirical findings, so forth and so on. You have to deviate from the expected standard of care. Now, this is a real elastic area as well, because how do you establish the standard of care? Well, frequently you establish the standard of care by bringing in experts who will testify about what the standard of care is for a forensic psychologist. And you might completely disagree with the testimony of that individual. So the trier of fact, be a jury or a judge, has to weigh what the definition of the standard of care, what is the standard of practice, who is defining the standard of practice, what are the resources that define that standard of practice. For many of us, the standard of practice is interestingly wrapped around the specialty guidelines for forensic psychology, which Dave DiMatteo is chairing the committee to revise those, but those are largely aspirational, though used in 2 states as enforceable. But a very strong document for defining what professional conduct is expected of forensic psychologists. The third D is damage. If there isn't any damage, there isn't any malpractice. Civil cases are wrapped around dollars. And that's why somebody sues somebody else. The resolution is based upon how much money is appropriate to offset the damage, be that substantive damage, meaning that you've actually had economic damage, you've lost your job, you've lost your property, whatever, the economic or non-economic damages, which are really difficult to define, pain and suffering, mental and emotional loss, and the amount of work that will be necessary to put it all back together for you. And many of you have worked in civil cases and know that individuals will say things like in a malpractice suit that if you're alleging emotional damages because of the malpractice, how much is it going to cost to fix this? Psychotherapy for the next 5 years, psychiatric medication consultations, etc. So those are the non-economic damages. So how much is the damage? How much, and how do you quantify that? and this is the last one, is there has to be a nexus, a connection between the conduct of the mental health professional, of the forensic psychologist, and the actual damage that occurred. So A has to be connected to B. What you didn't do or what you did do resulted in the damage directly. And then obviously, what are the intervening variables that have occurred? Somebody went to somebody else, that individual gave advice, interfered with that. But those have to be in place for a finding of a tort or a malpractice against you. Is that all that put together, they have to connect Dr. X with outcome Z and in the trial proceeding. You're all forensics. You've been in the courtroom many times. You've seen that happen. Science doesn't happen in courtrooms very often. Courtrooms are largely emotional creatures. Sometimes great, sometimes not, sometimes accurate, sometimes not. This connection is established largely through speculation and the presentation of evidence against you that your conduct, in fact, did result in the harm to that is reported in the case. All right.
All right, so Jeff, thanks for taking us through those 4 Ds. I certainly think you did a good job of connecting them all. So now let's talk about what happens if you get a licensing board complaint. As Jeff referenced earlier, this is one of the highest areas of risk to a psychologist nowadays, is a board complaint versus a malpractice lawsuit. There are malpractice lawsuits for sure, but licensing board complaints are a little bit easier and faster for attorneys to find information and charge a psychologist with. We know that most psychologists in approximately a 35-year career will receive a board complaint at some point of time in their careers. The risk, of course, is much higher for those who practice in more risky areas, such as child custody or forensic psychology, or for those who work with high-risk clients or patients. But all psychologists are subject to board complaints. Licensing boards differ on how complaints are filed and handled. A familiar expression applies in this case. If you know one state licensing board, you've known one state licensing board. Don't assume that your experience with one board will be the same with another board, or more importantly, that one's state's practice laws are the same as another's. In fact, they likely won't be the same. So if you relocate or you're practicing interjurisdictionally, become familiar through your state psychological association, ASPPB, the licensing board itself, other professional associations and relationships that you have, to learn about a particular state's law and board practices in which you are practicing. One other thing I'll mention is, of course, members of licensing boards change. And so you may have had a licensing board complaint when you've got certain people on the licensing board, but if you get another one 4 years later, there'll be different people on the licensing board, and that could impact how things are handled, not to mention what the subject of the complaint is. Keep in mind that ethical, well-trained, and successful psychologists receive board complaints, and that a board complaint does not equal findings of guilt or negligence. It may feel that way, but just because a board complaint has been leveled against you doesn't mean that you are guilty or that you've been negligent. In fact, many board complaints don't even result in wrongdoing being validated. And some boards actually, when they get complaints, determine, is there merit to pursuing this even further? You may not even be aware that board complaints have been filed against you, because if they're found by the licensing board to be frivolous on the face of it, you may never hear about it because it won't go anywhere else. So nonetheless, the process, even when you're innocent, can be unnerving and costly in some instances. Just so you know, the average cost of an uncomplicated board complaint can range from between $5,000 to $7,000, even for complaints in which no wrongdoing is found. The cost varies depending on how many complicating factors are brought forward. Often when there's a board complaint, there are numerous areas that are outlined as problematic. And so if it is more complicated, it can take longer, more attorney time, etc. It's really important to know what your particular malpractice policy covers before a complaint is filed against you, and what options there are for higher limits of coverage. Most malpractice coverage comes with a minimum amount of licensing board governmental affairs coverage, but in many cases, particularly depending on what you do in your practice, it is advisable for you to look at higher limits of coverage than what's included naturally with your policy. And again, the riskier your practice, the more important it is to evaluate what coverage you need. The costs will surprise you. They're actually quite reasonable to go from $5,000 to $10,000 to $50,000. Sometimes it's less than $100. Sometimes it could be $30 a year more for a difference of $15,000 more of coverage for licensing board defense. So look into that. Make sure you're adequately covered. And if you do have a board complaint filed against you, notify your malpractice carrier immediately, especially before providing any information related to the complaint to a licensing board. Even if somebody calls you from the board and says, I'm just making an inquiry, this is informal. Don't answer any questions until you've notified your malpractice carrier and you and they together determine if you would benefit from legal counsel. You want to ensure that you give notice so that the costs will be covered in accordance with your policy. Also, this is very important too. Seek support from your colleagues, but without discussing the allegations and the particulars of the board complaint. Receiving notice of a complaint can be upsetting, and self-care is tremendously important.
If you don't mind, this is such a very important area. Jana is absolutely right on. I've done thousands of consults. This is where psychologists get the majority of their disciplinary actions underway. We don't have a lot of malpractice suits. Yeah, I mean, if you engage in gross misconduct forensically, it is possible that the attorney will sue you. But this area becomes very complex. Nowadays we have like PsyPact, where you're registered in a state that is a PsyPact state, rendering services in another state. PsyPact's position is that you, when you do that, are responsible to follow the rules and regulations of the distal state. So if you're picking up a forensic case in Alabama, you are responsible to the licensing board in Alabama. And the problem with this area is that as we practice forensically, the risks just get much higher because the forum is adversarial. The clinical forum isn't generally adversarial. It can go south, like the case I talked to you about, but generally not. The fundamental of the courtroom is dialectic dispute. It is adversarial. And so the majority of the calls we get are related, not simply forensic psychologists asking questions about the laws in the state where they're practicing, but individuals who are inadvertently dragged into forensic proceedings as percipient witnesses testifying. The most important rule here for you as colleagues is to remember that if you don't know what to do, don't do anything. That just don't do anything. People, like, well, I went ahead and answered the questions that the board asked me. Well, let's think about that. The board asked those questions after those questions that they sent you went through their attorney, who established questions about how your conduct might be a violation of the rules and administrative code of the state X, Y, and Z. So they already have their attorney, and you went ahead and answered them without legal counsel. Very dangerous turf. And I think Jana is absolutely correct. you have to expect that sometime in your career as a forensic psychologist, you will have a board complaint, especially as a forensic psychologist, because of the adversarial nature of what we do. You go like, well, what do you mean, Jeff? Well, somebody is involved in some legal action and you testify against them and you dredge up the science to support an argument, they lose the suit. They're upset about that. Well, sometimes they like to resolve that upset by filing a board complaint against you. Now, are you going to lose? No, you're not going to lose. Is it going to be fun? No, it's not going to be fun. And it will move in geologic time. You know, it doesn't move in days and weeks. It moves in epochs and eras. So, you know, I had board complaints too while I practiced, one clinically, one forensically. They took years to resolve with the California board. And I was sued too. And we'll talk a little bit more about that later on. But this is such an important slide to understand. Some boards do their own hearings. Other boards don't. North Carolina or South Carolina does their own hearings. Why the board would want to hear a case, I have no idea. But whereas California and many other states have the hearings done by administrative law judges who are lawyers appointed to render opinions about whether the arguments do in fact carry the case of the allegations against a professional. So you could be in practicing in Ohio that uses an administrative law judge and working in a SIPAC case in South Carolina, and the board would hear the case. And you would be responsible for that. So when you do forensic cases in other states, and I've been an individual who has argued that I don't think licensing boards should regulate forensic practice anyway. I think that the court should decide if somebody's qualified or not. Separate issue. I'm sure I'll get a bunch of people yelling at me about that, but I don't believe that. But you know, you go to another state, another licensing board has authority over you, and now, sadly, folks, you've got two licensing boards that are regulating you: the one where you're doing the distal practice, and the one that you're licensed in where you live. And then you get into the complex area of law, like whose laws are the ones that you have to follow. What do you do if the laws conflict? What about mandated reporting if you're a forensic psychologist in state A, when the mandated reporting in state B is different? So important for you to have legal consultation. You don't know what to do, don't do anything. Let's get you a lawyer to help sort this out. So I didn't mean to prattle on there. I apologize.
No, actually, I want to kind of connect on something else that you said. You know, I've heard a lot of psychologists say, well, you know, when the board person called me, they said it was informal and they just needed that they felt like, you know, I just need a little bit of basic information. And so my thought was that if I didn't answer the question, it would antagonize them and then I'd be in trouble for sure. Well, that's just not true. It doesn't matter. You're not going to be able to sweet talk yourself out of a board complaint by answering a question that somebody calls you and asks you. You need to have legal representation so that you are helped in understanding what questions are relevant and what are not, and someone is there to support you. The other thing is that there's been a lot of interest in thought that some attorneys at times are interested in doing board complaints first to kind of see how they'll go before filing a malpractice case or claim.
Yeah.
And a lot of times board complaints that have been found adverse to the psychologist, all of that information can then be used in the malpractice claim. And so, one of the things that has been looked at is what is that relationship? And at this point, the relationship is there. It's not significant, but there is a relationship between whether a board complaint and a malpractice claim are filed against someone at the same time, or with the board complaint first And if it's successful or favorable to the person filing the complaint, that then a malpractice suit can follow later because there's at least an appetite there for and a potential for what we could probably get more money through a malpractice claim if we've already established by a board that you behaved outside of the rules and statutes for the state.
Yeah, I think that's a really important point that people understand. Frequently, lawyers will file an action against you civilly, but they won't do anything. Now that freezes the statute of limitations.
Right.
And then they'll go to the licensing board. And if they can get that sanction from the licensing board, then you're going to settle. You know, I mean, you're just going to settle. You're going to write a check. And so if back to the point is that you just don't want to do any of this without representation. So if the investigator, who by the way works for the board and whose job is to find things about you, wants to meet with you, it is absolutely appropriate for you to say, I would be happy to do that after I've retained counsel to represent my interests here, to make sure that we're all operating by the same set of rules. Now, they don't necessarily want you to do that. They'd be much happier for you to sit there without representation. But in a legal forum, representation is extremely important. Most of you are not attorneys. Many of you are, but are not. And you need the authority of the attorney and the insight of the attorney in what is, frankly, I'll say again, an adversarial circumstance. So very important stuff. All right. Why is it not advancing? There it is. I think we've kind of covered this already, but let's just beat it to death. Okay. First line. I know many of you have many friends who are on the licensing board, and they're friends that you drink beer with and go to dinner with. But the board as an entity is not your friend. The board works for the state. It regulates the profession, and it represents the interests of the public in managing your practice. So the board is simply not your friend. And my editorial is boards love to regulate. I mean, I just give them a minute or two and they'll come up with some new regulations that some of which I'm not sure I'm happy with, but their job is to protect the public. And they set those regulations up in the fulfillment or attempt to fulfill the mission of regulating the profession. As we've said over and over, always have an attorney represent your interests. You have a constitutional right to that, and you should make use of that. Do not represent yourself. You're asking for trouble. It's you don't know what the answers are. It's kind of like many insurance companies will pay for clinicians to have legal representation in depositions. Clinicians, not forensics, because in depositions, both sides of the legal action are represented by the attorney who is asking you to come to be deposed about whatever it is. But the only person that doesn't have an attorney there is you. And so if you ask a question in a deposition that you don't know, the one side will say, well, I can't give you legal advice. I can't answer that question. The other side will say, I can't give you legal advice. I can't answer that question. And the only person that doesn't have a lawyer there is you. I mean, that's a metaphor for exactly why you never represent yourself, and that you make sure that you have representation whenever you're exchanging information with the licensing board, and also at hearings. Never go to a hearing without your attorney. We're talking about your license here. And one, as forensics well know, one negative finding by a licensing board will haunt you for the rest of your career. You will be impeached about that every time you go out on the stand, because they're public. And so for you, it's probably even worse as a forensic psychologist to be sanctioned in any way by a licensing board. And as Jana said, many policies cover legal costs. You need to check with your carrier to see what your benefit is. And if you don't have enough coverage, pay for it. Just this is the biggest area. You might get sued. I mean, you might get hit by a meteor too, but the board actions are much more significant, and make sure that you're covered there. Sometimes there are cases where I've done cases with people who do child custody evaluations, good child custody evaluators. In the defense of a complaint, they will spend $25,000, $50,000 in the defense. They prevail, but child custody is the proverbial bar fight. Nobody's happy, and then when a child custody evaluator does a good job, everybody's unhappy. And so, while clinically that would be a disaster, that's a good outcome forensically because you probably hit it dead center, but you end up with a licensing board complaint, and these can be rather expensive. Usually not, but the forensic arena, I think, is where the costs are much more substantial, because they've spent money in a legal action and it didn't work out, and they're angry about it. And as I said earlier, the circumstance is adversarial. Redundant. Always be represented by an attorney. Remember that findings can trigger administrative actions. What do we mean? An ethics committee finding, a hospital staff finding, a finding by a peer review body can wind its way into the administrative courtroom, and a licensing board will, in pro se, sua sponte, file their own action against you, and not paying any attention to the fact that the levels of proof are different depending upon those findings. Preponderance of the evidence, 51%, clear and convincing evidence. And then the highest, beyond a reasonable doubt, which is the finding of proof in a criminal action. I've been an advocate that in administrative actions, it shouldn't be preponderance of the evidence. It should be clear and convincing evidence wrapped around the results of the evaluation of the case. It should be clear and convincing, not 51%. If you flip a coin 101 times, you got 51%, and it's still a random act. But you need to understand these things and understand that very frequently a finding on hospital staff, or the removing of a hospital staff privilege, or an insurance company's recuperation of costs against you for overbilling or misbilling, you're going to find yourself dealing with a licensing board action. It's a very safe profession that we practice by and large, but a little bit of care is going to go a long way here. So let me see. All right, Jana.
All right. So we've been talking a little earlier about some high-risk areas in which board complaints and even malpractice claims are more likely to occur. I wanted to share with you some of the areas in which severe claims are mostly seen. I'm sure it's not surprising that suicides had the highest exposure. With suicides, losses are impacted by several different variables. One, the net worth of the individual who committed suicide. Two, the loss of earnings, of potential earnings, and the age of the person. So how much longer did they have to continue, if they had not killed themselves, to provide for their families or themselves, or increase their income. Common allegations and findings in suicides include a failure to assess the threat properly, failure to act or intervene appropriately when threats are made. So looking again at, was hospitalization called for, or was there a recommendation for a higher level of care? What was the plan of how to intervene when threats are made? And failure to collaborate with medicating physicians, psychiatrists, and then inadequate documentation and consultation. You've heard me and Jeff talk at different times about the importance of consultation and documentation, and this is one of the reasons why. There also are incomplete suicides. Incomplete suicides are those where someone attempted to take their own lives, but didn't kill themselves, but if they shot themselves in the head or in the mouth, they're disabled for life. And that's, again, where the calculations for care, that would be an additional variable that would go into what the dollar value might be in a malpractice case with an incomplete suicide. With assault and homicide, there are certainly similar alleged areas of vulnerability. For example, assessment. Was a proper assessment done? Was it documented? What's the intervention that was used? Was it something that meets the standard of care, as Jeff alluded to earlier? Inadequate consultation. But duty to warn is also a factor in states in which there is a duty to warn obligation. Allegations of inappropriate sexual relationships, boundary violations, continue to be a high-risk area. Additional alleged boundary violations, which are also dual relationships, might include family members of psychologists actually working for clients or patients, or recommending the psychologist recommending friends to work for clients or patients. So there has to be a real clear separation between what your role is as a psychologist and your relationship to your patient or client. So those are some of the highest risk areas that I think are important for us all to pay attention to, and some actual reasons for why sometimes psychologists end up having to pay damages because they haven't done some of these things, such as documentation or consultation, or haven't intervened properly. Let's go to the next slide, Jeff.
I think I've got it up.
Oh, I'm sorry, you do have it up. I'm sorry.
I'm sorry, there's a gremlin in my computer. I don't know why it jumped back. But
that's all right. That's all right. So now what about high risk areas, again, that are trending? So, you know, boundary violations, suicide, assault and homicide have kind of always, if you will, been in the mix of areas where complaints or suits might be brought against psychologists. But then there are also some real high risk areas involving care. So one of them is improper care or treatment. And the improper care or treatment can include allegations of psychologists who are physically, mentally, or emotionally abusing clients or patients, or alleged failure to monitor. So this happens sometimes in the area when psychologists are working in inpatient treatment or incarceration facilities where there may be some interactions with patients that are not in the therapy room, but might be in the way that they are interacting with those patients or clients. So that's improper care or treatment, some examples. With evaluations, and this is particularly true for those of you who do forensic evaluations, psychologists have been alleged to have failed improper assessment of the severity of one's mental status. You missed something, or you didn't further explore an area, and then that individual was cleared in some way for some action, or was discharged from some facility, and then commit some kind of harm to someone else. Those are usually where the claims are brought about that the evaluation didn't properly evaluate the person's mental status, or the person's potential for dangerousness, or properly looking into past experiences of dangerousness and putting that together with one's psychological status. And then, of course, also there is the whether there was proper treatment and monitoring. This is one of the things that is seen a lot. Well, you may have written a good treatment plan, but was it monitored? Did you follow through on it? Or did you designate a team or a group in some way to follow through with it? And did you monitor it as the author, if you will, of that treatment plan? That can be a vulnerability that leaves you open to malpractice suits or board complaints. And then, of course, there's the improper billing, the Medicare investigations, or audits by CMS or CMS designated agencies. And then another one is employment practices, claims against insureds for wrongful employment practices. So you may have a practice where you have a couple of staff. There may be an intake worker, there may be a scheduler, there may be a receptionist, there may be a bookkeeper, or someone who does your billing, all of those things. As a business owner, you are required to follow through with employment law and abide by it. And then some other areas are refusal to employ or promote a qualified applicant, or unsubstantiated or improperly documented demotions of an employee or staff member, or improper termination, harassment, or discrimination or humiliation. So those are areas that are trending. One of the areas that is where that a lot of insurance companies are looking at is fitness for duty evaluations. There seems to be a pretty dramatic increase in the number of complaints and lawsuits based on fitness for duty. It's a corollary, if you will think about it in concept, to the child custody evaluation. The person who loses is really mad because they didn't just lose the case or the evaluation or what they were claiming. They've lost income or wages or reputation. And so fitness for duty evaluations are starting to climb up a fair amount, not as much as custody evaluations or assessment of dangerousness, but it is something that might be seen as trending.
Yeah, I just as a circumstance becomes more adversarial, your risk management should skyrocket. I don't know what to say. We choose to practice forensics. It's a great field. It really is an intellectual challenge. It's psychology helps the court because we have our assessment skills. The other forensic professions don't have that, but it is a risky circumstance. So then, just to cite you the trust risk management model, which is a model that we wrote in our book on risk management. There really are three fundamental things that you need to do to manage risk. And there is no way to reduce risk to zero. So if any of you are watching to figure out how we will tell you to get your risk to zero, that's fantasy land. The only way you can get to zero is quit practicing. The circumstance is adversarial. You keep good records. It's paramount. How long should you keep forensic records? So for sure, the minimum is as required by your respective state for clinical records, but there are individuals who have written that there are arguments for maintaining them forever. Well, that's the other extreme, obviously, but forensic records are not the same as clinical records. And so what records do you keep? What records do you not keep? Does the lawyer understand that what your record keeping policy is, what you are going to keep or not? And then if you don't know what to do, consult, record your consultation. You consult with somebody, write the consultation down. Because frankly, if it isn't written down, it never happened. And so even though you wrote the consultation, it becomes evidence like another person testifying about what occurred. And the last one, and I think this is extremely important generally, is to use the appropriate informed consent. Over and over, people just use the same informed consent for their practice, whether it's couples practice, collateral practice, child therapy, adult therapy, forensic psychology. Well, those rules are different. And so many people haven't read their informed consent for years. They have no idea what they're having somebody consent to. But arguably, an appropriate informed consent is a contract that you have. What is your duty to report dangerousness as a forensic psychologist? What is it if your duty to report child abuse as a forensic psychologist? Do you have a duty? And that's been resolved in California, but other states not, that forensic psychologists don't have the same duty. But other states, nobody's bothered to ask the question. So what are the rules? You need to really take a look at your informed consent and tool it to say what you want to say to the attorney who's retaining you or to the agency that's retaining you for their services. Doing evaluations for school districts. Those are forensic evaluations. Your client's the school district. What's the relationship that you have with them? So just a very important area. And then those are citations related to what we've talked about. There are many articles out there. I see we have some questions, Jana.
Yeah,
We've got a little time left to answer questions.
Yeah, a couple. One's pretty fast. Somebody's audio cut out when I was talking about the average cost of resolving a board complaint. And could I repeat it? So yes, the average for an uncomplicated board complaint ranges between $5,000 and $7,000 per complaint. Again, it can be a little bit higher than that, depending on how many allegations are in the board complaint, which ones stick, which ones don't. But that's the average for a fairly uncomplicated one. Others, especially forensic related, can run 10, 20,000, maybe even up to 100,000. So again, those are the much more complicated ones. So yes, we can answer that question. So Jeff, here's one about duty. Do you have a duty with someone who calls you to do a neuropsych eval when you don't know how, if you have no relationship with that person?
Common question. And you have an ethical duty, right? To do the right thing. You're not going to hang up the phone on that individual. Could you be sued? Well, anybody can sue anybody, right? So if somebody calls on the phone and says, I'm suicidal, I need to be seen right away, there is a heightened duty there compared to somebody who calls to see a neuropsychologist and you don't have that specialty. Courtrooms are forums of argument. How did you discharge the duty? But duty is elastic. And so your duty is still very, very small. You know, you're not going to hang up the phone and say, I don't handle that, or I don't want to deal with that. But you may have discharged that small ethical duty by saying, you need to go to your nearest emergency room. I can't see you. And it sounds like you're in a real state of pain right now. And so just dial 911 and go to your nearest emergency room. There's ethical duty and legal duty, right? We're all ethical people. So we got an ethical duty.
Mm-hmm. Okay. So here's another one. This is not quite about malpractice issues, but what is your opinion of being represented by the AG's office when working for a state hospital or state mental health department versus having private representation in court proceedings?
Well, a lot of my friends are attorneys working for AGs. These are attorneys who know frequently criminal law. I recommend as your colleague that you get someone who specializes in mental health law, who is an expert in administrative laws and specifically dealing with board complaints in your state. You can be represented by the AG, but you know what? I frequently believe that if some lawyers, not all, but some lawyers, they don't know the answer to something, they make it up. That doesn't help. And so I would recommend strongly that at a minimum you have consultation with someone. If the AG's office is going to represent you, and they may insist upon that, you may not have the authority to do something beyond that. You still have the right to consultation with a lawyer who has expertise in these kinds of actions. And usually the AG will welcome that because it's not their bailiwick. Great question.
Yeah. And this is one that I'll take a stab at first. If you're going to take a hiatus of a couple of years from practice, is there a risk to not renewing your malpractice insurance during this time period if your active cases are all completed? I realize in forensics, sometimes we consider no case to ever be over. Or if you retire, at what point can you terminate malpractice coverage? So there are lots of elements to this. I'll try to give the high level version. So it is never a good idea to stop with malpractice coverage unless you are retiring and you purchase what's known as a tail. So a tail costs a little bit more than what your annual premium is. And what it does, whether it's a claims made or occurrence policy, it means that if there is any kind of legal proceeding that is filed against you or levied against you after you have retired, you have sealed your coverage for that period. If you stop paying your malpractice insurance and you do not get a tail, then if there is a suit filed, even if you paid all of your premium for those previous years, that coverage is not there unless it's an occurrence policy. That's the main difference. And so you always want, if you're going to retire, to get a tail. If you're not going to retire and you're taking time out, it's advisable for you to continue paying that coverage, because you never know when a claim might arise, because of statute of limitations sometimes are quite broad. But just make sure that if you retire, you buy a tail, even if it's claims, when it's claims made, so that everything that you've been paying in and anything you've done in your career is covered. Okay, so here's one about, should we have a clause on length of maintaining records in our service agreements with an attorney?
Say again, I'm sorry, Jana.
Yeah, I'm not sure I understand that last part. Should we have a clause on the length of maintaining records in our service agreements with an attorney? You were talking about informed consent and the—
Great question.
Yeah.
Yeah, it's a great question. Actually, because we don't have a definition of how long you have to keep records. So that if you're going to keep your records consistent with the state law, some states are 5 years, some states are 7, then that should be a part of your informed consent, so that the attorney understands that at 7 years you're going to purge your files. Because we don't have the answer yet about how long you have to keep records. It's a matter of debate. Jan Sani, as I said, wrote an article about it. Still unclear.
Okay. Now let's switch gears a little bit and talk about PsyPact. There's a good question about PsyPact. My understanding is that PsyPact psychologists are not required to comply with all laws of the receiving state where the patient lives. There are only a couple of laws that may be complied with, such as Rule 4.10 of the receiving state's law to protect the health and safety of its citizens. Is that correct?
It's not correct exactly. The implication from PsyPact is you have a responsibility to be familiar with the laws of the receiving state, and they are unclear about what laws fall into the health and safety clause of the statute. And so I would be very careful with things like abortion counseling or issues that have to do with mandates to report, because not even PsyPact has that defined yet. So I would not rely on that. It's true that you are not responsible to comply with all the laws, right? But what's the problem here is that we don't know exactly which ones you are supposed to comply with.
Good. And then this is, you had talked about duty to report has been resolved in California. How so?
I haven't been practiced in California for a long time, but my understanding is there's a San Diego court finding that said that forensic psychologists' duty to report child abuse is reduced when they're doing forensic evaluations in California. But the duty to report beyond that is not. I don't want to be held 100% to that, but I'm pretty sure I'm right on that that is correct. Jana, does that ring a bell for you?
Well, it doesn't. I'm not
San
firmly.
Diego. San
Not
Diego
firmly,
case.
no.
I'll look it up. Those of you that wrote that, email me. You can get my email. It's just Younggren at salud.unm.edu. I'm going to hunt that down, but I'm pretty sure that California has a modification of duty to report. Important question, though, is if you have a duty, which you arguably do, that should be in your informed consent. so that the attorney who's retaining you understands that you have that obligation.
Okay, great. Do new licensing board members typically receive training and evaluating complaints filed with the board? How many states provide such training at all?
It depends upon the state.
Does, yeah.
It really does. I mean, when you're in Wyoming, I mean, what have they got, 175 psychologists in the whole state?
Yeah.
As compared to California. Of course, states like California, New York, Ohio, Florida, their board members are trained. Others, I don't know for sure, but my bet is probably not formally trained. Well-meaning, capable, competent, committed, no question about it. They're not nefarious at all. But you know, I've done some hearings with for states that have been run by boards that did the hearing, and I've been less than thrilled with what went on.
So a couple of people typed in the chat box while you were talking, I mean the Q&A box, that it's called CANRA, C-A-N-R-A, for the California Duty to Report.
Okay.
So we can pursue that. All right, let me go back up to one of these. What value do you see in professional organizations' ethics consultation panel opinions? For example, IACP's PPSS. So the value of ethics consultation panels in professional organizations.
I don't know what to say. I mean, some of them are very good, some are not, some are well-meaning. So I think that you've got to consider the source. I think that you know, ethics committees have new members on them. Sometimes they're not familiar with the evolving standards of care. For us as forensics, do they really know anything about the specialty guidelines or the standing of them, and what's the definition of them, and so forth. So you know, I think that the ABEP consultations are arguably very good. I think that I don't think AP really does consultations anymore. You know, they're more putting out global kinds of opinions and directions, and so I think local organizations that have consultation services, consultation is good. I mean, obviously, it helps establish the standard of practice, but if somebody is a senior psychologist with a long resume of expertise in an area compared to another individual who doesn't, I think that's an issue that you have to evaluate. And what do you think, Jana?
Yeah, so one of the things that I often will say to folks is, while certainly we all talk about consulting is important, it's also important to remember that when you consult, you're not deferring your own professional responsibility. And so if somebody, you call a consultation service and they recommend something, and there's something inside you that says, gosh, you know, that just doesn't ring true to me, or I'm not sure, or I don't think I understood that correctly, to decide then to say, well, but you know, they were the ethics consultation service, and so I'm going to go with that against my better judgment. You can't defer your ultimate responsibility. And so I think it's kind of like what we do with a lot of things. You know, you want to get more than one opinion. Specifically, if it's something that's very complicated, it's important to have different views, because when we talk about what is the standard of care in the first place, you know, it's not just what does one psychologist think. It's what would most psychologists with the same level of information and training do in that situation. And so if it doesn't feel like it's a good consultation, or you have questions that went unanswered, or you didn't get substantiation for it, then I would encourage you to ask others and get additional consultation and see if you get some consensus. So, well, Jeff, I think that we're towards the end here. We've still got a couple of questions we weren't able to get to, but I think that our time is up. I've really enjoyed talking with you and being with this esteemed group of people. So thank you for including me in this. And I want to thank the audience for your participation too.
Absolutely. Thank you so much, Jana. Thank you so much, Jeffrey. I mean, you could tell from the sheer number of questions and the different variety of that you gave people a lot here to think about and consider. That wraps up another wonderful Law and Mental Health series presentation. Next week, again, we'll have Ofer Zur talking about therapeutic ethics that we see on display in movies. So I hope you can join us then. Until then, have a great rest of your week.
Thank you.
Thank you.